Good afternoon. I'm Michael Williams, live outside the Broward County Courthouse. You see the media tents behind me, the national media assembled here this day. On the 17th floor, the legal drama begins to play out. The death penalty sentencing phase, piece of this long, arduous journey for families in the case of Nikolas Cruz, now 23 years old, confessed to the murders of 17 people at Marjorie Stoneman Douglas High School, February 14, 2018. He made that plea last fall, and now the long sentencing phase of the trial, perhaps lasting months, begins. Will it be death or will it be life in prison for Nikolas Cruz? Again, now 23, 19, when he walked into that school with an AR-15 and shot and killed those people on that awful, awful day that has so imprinted itself on our memories, and most particularly those, as we show you footage throughout this streaming broadcast, of the families who came here today to be in the courtroom. One of them telling me last week, we need to be there for our daughter. One dad told me, you saw their tears, you saw their grimaces, you saw images of Nikolas Cruz sitting there with his defense team this day. I'm joined for our discussion with legal experts. Sitting with me right now outside the Broward County Courthouse is Douglas Rudman, former prosecutor. Mr. Rudman is now a criminal defense attorney. Lourdes Casanova, also a defense attorney now, but she too, a former prosecutor in Palm Beach County. And Mark Aggravators, who is a defense attorney as well, but also was a prosecutor in Broward County. And they're taking time to be with us, and we appreciate that very much. I think for our three legal experts, let's begin with the fact that Michael Satz outlined what will be before jurors and what the prosecutors ultimately will have to prove in many months of testimony to come if they want to get a death penalty verdict, which must be unanimous from this 12-person jury. 7 men, 5 women, picked from a pool that began of 1,800 people a few months ago, and now 12 people sitting in this community, ordinary citizens like you and I, who will have to make that most profound determination. Here's what Mr. Satz said, and then Lourdes, on the other side of what you hear from him, help explain to our viewers what's going on here. Let's listen to Mr. Satz.
3 days before these brutal murder, this massacre, the defendant in this case made a cell phone video on his cell phone. And this is what the defendant said. Hello, my name is Nick. I'm going to be the next school shooter of 2018. My goal is at least 20 people with an AR-15 and some tracer rounds. It's going to be a big event. And when you see me on the news, you'll know who I am. You're all going to die. Ah, yeah, I can't wait. Ah, yeah, I can't wait. Cold, calculated, manipulative, and deadly.
Lourdes Casanova, again, joining us, former prosecutor, now criminal defense lawyer. Walk us through and explain for all of us watching and for those of you watching at home, break down what the prosecutor had to say, and we'll also get to in a moment with our other guests the fact that the defense did not put on an opening statement as would be typical. But first to what Mr. Satz said and why it's so pivotal to the ultimate outcome here. Ms. Casanova.
Well, Michael, what really stood out for me was the words cold. I believe he said cold, cruel, and that's exactly pulling it from the jury instructions for death penalty evaluation, what a judge has to read to a jury. So essentially the state has the burden of proof, even though we're now in the penalty phase. It's not a question of guilt or innocence, but the state does have the burden of proving beyond a reasonable doubt at least one aggravating factor in order to justify the death penalty in this case. So one of the factors listed in the jury instructions is specifically that the murder was especially heinous, atrocious, or cruel. A second one is that the murder was committed in a cold, calculated, and premeditated manner. So the fact that the state used cold and calculated in their opening statement shows an intent to show, to prove that aggravating factor, and hopefully the evidence will back it up.
Mark Aggravators, weigh in. There will be gruesome evidence presented to jurors that you and I, both in the media and at home, will never see, but that the jurors will have to look at. But it's that legal definition that Ms. Casanova pointed out. that is at stake here. Beyond the emotion, beyond all of that, which will be gripping and almost enormously, if not nearly impossible to watch, there is that legal definition of where they must go. How hard would it be? I've had people say to me, he pleaded guilty to 17 murders. We know he did it. How hard is it to get a death penalty conviction? Speak to that from a legal point of view, Mr. Aggravators.
Well, it would have been more difficult if this was before 2016. Actually, it would have been easier. Strike that. When the jurors had to be unanimous, meaning all must agree to the same outcome. It's changed. Now it only takes one juror.
Because you need a unanimous jury vote now. You didn't.
Now, strike that. Now it's unanimous. Exactly. So all it takes is one to say, I think he should live. But you got to give it to Mike Satz. I've never seen him perform in the 30 years that I've been in this arena. I've never seen him give a statement. And boy, did he know the facts. And it was chilling when he went through and listed the aggravators. It's hard if you're being intellectually honest, regardless of where you stand on the ultimate outcome, to not embrace all 7 of the aggravators as being legitimate. Heinous, atrocious, and cruel? Yeah, I think so. Cold, calculated, premeditated? Yes. Significant number of victims? Yes. Previously convicted of a felony? Absolutely. The murders were committed during the commission of a burglary? Yes. It hindered a government function? Of course. And the victims were public officials? Yes. All 7, it looks like, will be easy to prove.
Mr. Rudman, Doug Rudman, again, former prosecutor, Palm Beach County, now criminal defense attorney. Let's turn to the defense piece of this. We had expected that they would, as is often the case, I would say overwhelmingly, will present an opening statement. The defense did not do that. They said, we're going to hold, we're going to reserve our right. What might have been their thinking?
Well, that's actually some really next level lawyering that they're really doing a great job in the defense here, because a lot of times when you do your opening statement, you're telegraphing the theory of your defense to the state, and the state then has the opportunity to fix their questioning, fix their dialogue, fix their message to suit the defense you're putting forward. Here, now after the state rests, the defense halfway through gets their opportunity in an opening statement. They get to get up there, and then they get to show the jury what their case is about, the mitigators.
And as Doug and I sit here outside the Broward County Courthouse complex, you see behind the tent just some of the huge assembly of media here, a packed courtroom, of course, as you see families who gathered here, the families of the loved ones slain on that awful day, February 14th, 2018, that Valentine's Day where they sent their children off to school and got the phone call that has changed their lives forever. We talk a lot about closure. Families have told me there's never any closure for what happened that day for us. They try to move on simply as best they can.
Michael,
Mr. Rudman, then to Ms. Casanova and Mr. Aggravators. We talked a bit about where the prosecutors will have to be legally. From a defense perspective, what is it they have to leave in jurors' minds? What do they have to try to tell them about Cruz, Mr. Cruz, Nikolas Cruz, that would make them say no death penalty?
Well, we understand that his mother, even when she was pregnant with him, had some substance abuse issues, mental health issues. And these are things that Nikolas Cruz was saddled with even before he was born. And if they make this more of a physiological issue than a psychological issue, that it was simply as a course of nature that he matured into this killer that we see today. That is something that would work against the aggravator.
As a layperson, I don't quite understand that. I would think it would be backwards, that they would want to prove a psychological component, not a physically something that's born with. Explain that a little bit.
Well, psychological illness is a lot different than physiological illness. Physiological is something we can see through electroencephalograms. We can see through medical testing. We can see a lot of those things. I mean, psychological illness is a lot more difficult to put a thumb on.
Let's, Ms. Casanova, weigh in on your view, your expertise as a criminal defense attorney who sat on the other side as a prosecutor about what the defense must do. And then really to a question that's been asked again and again, if you weave into that thought, a lot of people said, why has this taken so long? 2018, it happens. Obviously, COVID delayed much. But even from the initial post-COVID spike until now, it's taken forever. It's now going to be months of testimony. So a two-part question. First, where defense needs to be. Answer that. Then second, why is this taking so long? A lot of people ask that very simple question. First to the first part.
So going to Doug's point about bringing up physiological versus psychological, as a defense attorney, I would probably bring everything up, everything that I can, and see what sticks. Because the jury instructions permit that. So I always go back to the jury instructions. That is the law. And it's actually taken from section 921.41 Florida statutes. So, and what that says is that the defense can bring up essentially any mitigating factor. And they don't have to prove it beyond a reasonable doubt in the same way that the state has to prove aggravating factors beyond a reasonable doubt. So for the defense, they only need show the greater weight of the evidence. So more likely than not as a mitigating factor. So that's
And
a
again, that could be his childhood. It could be mental health issues.
It could be
They
correct,
verify.
and it doesn't.
Give us a sense.
Absolutely. It could be anything. It could be related to his background. It could be related to his character. It could be related to the case itself. But of course, it doesn't have to be. So really, as a defense attorney, you want to try to bring up anything that you can show at a minimal level, at the greater weight of the evidence. Doesn't have to be beyond a reasonable doubt. And then from there, the jurors will have to decide if the aggravating factors outweigh the mitigating circumstances provided by the defense. And to answer your other, I apologize, go ahead.
No, please go ahead.
To answer your question as to why it's taking so long, I know people say the wheels of justice spin slowly, but truly it's a matter of life or death in this case. There, I'm sure, has to be a lot of preparation. I know that in any of my cases, I prepare a lot, but of course, when you're talking about life or death, they need to prepare the witnesses, they need to prepare the evidence. The state does have quite the uphill battle, despite what some people may believe. You know, it may seem like an open and shut case, but really having to, like Mark said, this has to be unanimous now, and having to prove aggravating factors beyond a reasonable doubt. And I will point out, Michael, it's not just showing unanimously that, or determining unanimously that there are aggravating factors. It also has to be unanimous, the determination that the aggravating factors outweigh the mitigating circumstances. And even then, the last factor, the last part of the jury instructions say that even if you find that the aggravating factors or factor outweigh the mitigating circumstances, you can still decide that death is not appropriate in this case. So that's the discretionary
boil
part.
that down to plain English for people who've never been in a law class. Aggravating, give us an example of what hypothetically could happen there.
Well, so the jury instructions actually do talk about examples of what could be an aggravating circumstance. And I know Mark brought it up as well, but that the murder was especially heinous, atrocious, or cruel, committed in a cold, calculated, premeditated manner, whether he had any prior felonies or capital felonies. All of these things are factors that could be considered aggravating circumstances that are considered in a death penalty case.
Mr. Rudman, then we'll go to you, Mr. Aguilar. So now put your defense lawyer hat on. What would mitigate against that?
Well, certainly mitigating against this is that there was some sort of mental illness or something that he had in him that was pushing him to do it. Now, when we talk about aggravators are really what makes this murder more heinous, more detrimental to the world than the regular murder that we have, that we see in courthouses across the
They're all heinous, but
they are. Yes, sir.
You're trying to make
But
is
that there are murder cases that are tried all over the country on a daily basis. What is it about this murder case that deserves the ultimate penalty?
And Mr. Aguilar, you've heard this back and forth. Weigh in with your thoughts, both on the hurdle for the defense, the length of time it's taking, and the challenges, which Ms. Casanova, I think, incisively pointed out that I think there's this assumption, for some anyway, that this is a slam dunk. It's not a slam dunk case by any stretch of the imagination. Kind of incorporate everything you've heard and your thoughts.
All right, it's not at all a slam dunk. All right, I have a number of thoughts, okay?
Go ahead.
First, with utmost love and respect to Mr. Rudman, I don't think it's next lawyering to defer your opening statement in a case like this. I would imagine in certain cases there are. In this case, I would have been chomping at the bit to stand up as a defense attorney. There's no surprises. The state knows you're going to put on every possible person he ever said God bless you to, any other mitigators you can come up with. There's no surprises. There's no trial by ambush. So the state knows exactly where you're going. The defense could have gotten up there and done the human thing, which also helps their client, which is pay homage to the victims, explain that their client is not denying what he did, that he's already accepted responsibility, that he saved so much time out of respect for the families by pleading guilty. All of the things that they can say, I can go on and on and on, I believe should have been said up front. Why? Because now that they're going to get into that heinous evidence, and by the way, I'm one of the few people, unfortunately, who's had the displeasure of seeing that evidence because I represent Scott Peterson, the alleged coward of Broward, who, quite frankly, is innocent and should never have been charged. So I've seen.
We're talking just briefly, since you brought it up. We're talking about the officer at the school who did not go into the classroom and has been charged with that. Argued that he should have gone in and been proactive to try to stop them. We'll talk about that piece of it another time. I just wanted for our viewers to understand who you're talking about, but continue your thought.
So I've had the displeasure of having all of the Cruz evidence dumped on me, and my entire life for the last several years has been reviewing that stuff, and I cannot get out of my head the videos shot by kids in the classroom, seeing in real time what they're seeing. It is so unbelievably disturbing that that's the type of stuff that I think prosecutors are going to have to really propel these jurors into issuing the ultimate sanction, which, by the way, the Supreme Court has ruled death is different. Death is different. So what makes this case so different than every other pre-murder case? And there's a lot of reasons why it is.
Let me one question, and I'll start with you, Mr. Aguilar, and work our way around in our remaining time. I want to be clear again for those of us so that we understand the process here. 17 murders, pleaded guilty to all of them. The death penalty, ultimately, after what some expect to be 3 or 4 months of testimony, where you can get mental health experts in, where you're going to see this gruesome evidence, where you're going to hear from police, where you're going to hear from a wide range of people, both supporting the prosecutor's contention about what happened there, about the video he made on a cell phone that would seem to point or did point, the prosecutors argued, to premeditation, about the mitigating factors. But when you see all of that, ultimately this jury of 7 men and 5 women, there are 10 alternates, by the way, in case one of the regulars does not make it through the whole trial, they'll decide each verdict victim by victim. Victim number 1 ultimately be ruled for death or life. Am I correct there? To be one victim at a time where they'll make that ruling. So there'll be 17, I don't want to say opportunities, that's not the right word, but there'll be 17 circumstances in which the jury will have to make the judgment, death or life. Am I correct there? Let's start with Mr. Aguilar. I promised we'd start with you. Let's start
That's
there.
okay. I defer to Mr. Rudman on that. Go ahead.
Am I correct on that?
Yes, there has to be 17 different findings, and any one of those findings, if it's unanimous for death, he can get the death as to one of the murders that he's pled guilty to. So even if they find the aggravators, that way the mitigators, and death is unanimously recommended as to one of the victims, it doesn't matter what happens to the other 16 of the victims.
You will still have a verdict rendered for all 17, but each will be its own single verdict about death or life.
Yes,
obviously, you get one verdict that says death. And by the way, any death penalty case is automatically appealable, goes to automatic appeal in Florida, for those of you wondering. So, but each of those 17 victims, the families will ultimately hear a verdict rendered on their loved one in each particular circumstance, death or life in prison.
And even then, again, like we said many times before, either way, Nikolas Cruz is going to die in prison. It's just a matter of how long it's going to take and by what method.
And let me ask, Mark, we'll begin with you, then you, Ms. Casanova, then you, Mr. Rudman, for closing thoughts. You're the legal experts. What am I not touching on? What do you think you're going to be looking for? Set that for our viewers about what they should anticipate, begin to look for. There'll, of course, inevitably be the unanticipated. I would begin that question with one thing. We heard a lot about insanity pleas. Ultimately, the judge said no, he could stand trial. Layman's question. You can't pop up in the middle of a trial and start trying to make your insanity plea again. That's done and finished with, correct? So I begin there, then ask for your thoughts. We'll start with you, Mr. Aguilar. What we should look for, both in terms of process, what our expectations or what the expectations should be in the coming months. Again, Mark Aguilar, former prosecutor and now criminal defense attorney in Broward County. We'll start with you, sir.
So I would start off after I acknowledge to the families and everyone how heinous this was. You can't hide it. You don't have any credibility unless you say this was a horrible scenario, a horrible, abhorrent crime. He took responsibility. He pled guilty. You've got to acknowledge that. I think they should have done it out of the gate. But then you start to move into who in their right mind would ever do such a thing. Then you move into he was not in his right frame of mind. He wasn't someone like you or I. He's someone who, before he came out of the womb, he started at a deficit through no fault of his own. His own mother was boozing and was drugging, and that caused him to have, and again, I don't know if all this is true, this is what we're hearing, have some type of mental defect that then continued on through his life. It led to bullying, it led to mental illness, and ultimately led to him doing the unthinkable.
Mr. Aguilar, thank you, and stand by. And Ms. Casanova, your thoughts, your final thoughts. Again, same question to you, please.
I agree with Mark. And to put it succinctly, what we can expect is a trial. Even though we are in the sentencing hearing, the sentencing phase, we can expect a full-blown trial. So we had the opening statement, we're going to have testimony, we're going to have evidence, and we're going to have a closing argument, and then we're going to instruct the jury with what the law is and what they need to do to determine whether this is going to be a life or death sentence. I'm going to expect from the defense to see any and all factors that are listed in the jury instructions and not listed, because in the jury instructions, I know I keep going back to it, but that's what matters. So in the jury instructions, they do give examples of what can be mitigating. So for example, if he doesn't have any priors, if he was experiencing extreme mental or emotional disturbance, if he didn't have the capacity to appreciate the criminality of his actions. So I expect the defense to try to hit on every one of those factors, but I also expect them to capitalize on the fact that the instructions do say mitigating circumstances could be anything. And then on the other hand, I expect the state to try to hit as many of those aggravating factors and prove that beyond a reasonable doubt, so they can have many bites at the apple. All the state needs is one aggravating factor to move forward, so then the jury can consider whether the aggravating factors outweigh the mitigating factors. All they need is one.
And to all of you are encapsulating for our audience, this is why we're going to hear months of testimony, expert after expert on both sides of this equation, coming before this court. Again, we're outside the Broward County Courthouse complex, 17 floors above it, one expert after another to make that case. I would ask one quick question, Ms. Casanova, then we'll wrap it up with Doug Rudman. A lot argued, I couldn't get a fair trial here, should have been a change of venue. And also in today's world, how do you make sure the jury's not polluted in their thinking? There's so many media sources, so many ways for somebody to say, I won't listen or watch anything else. That's pretty tough with a 4-month case. Just your general thoughts about that. The change of venue debate that will go on would probably be part of an appeal. And the larger issue of trying to make sure a jury is mentally and emotionally sequestered from all the outside influences, even though they take an oath that they will be.
Well, Michael, of course, the jurors cannot do independent research, but in terms of whether anybody has heard of this case, that shouldn't be an issue. And the central question is always, can a juror be fair and impartial? So that's always the question that's asked. And of course, a juror may say that, yes, I can be fair and impartial, but it's up to the judge and the government as well as the defense attorney to determine who can actually sit and be fair and impartial, despite maybe having heard certain things on the news. Of course, now that they're sworn in officially as the panel, they can't do outside research. But
Sure.
The fact that they already knew about this case doesn't necessarily disqualify them and doesn't necessarily prevent them from being fair and impartial, although the defense will certainly bring it up on appeal.
And Doug Rudman, one question. We talked about 12 people, 7 men, 5 women, ordinary citizens like you at home and I. I'm sure after many cases you've talked to jurors. Talk about the enormous pressure these people feel. I'm not talking about what verdict they will render, but the enormity of the task ahead of them. And final thoughts you have.
Well, first off, anytime someone gets picked to serve on a jury, it is very, very, very much a daunting task. It's someone sitting in a court of law having to determine whether or not someone's liberty is going to be taken away, and especially in this case, whether or not someone's life is going to be taken away. Ms. Casanova was right on when she said that the state only needs to prove one aggravator, but the defense only has to convince one juror. And since 2017, the law says that there's no hung juries in this. If there's one juror that disagrees, that's a life sentence. So now when we're looking at it, instead of proving one aggravator, they just have to convince one juror that a mitigator is warranted to save his life.
But they do have to convince one juror 17 times.
That is correct. That in all 17 instances.
Any final thoughts, sir?
One thing that I would say is this: is that the jury verdict is not the end of this case, because ultimately the judge has to be the one to actually hand down the death sentence, and the governor has to execute the sentence, excuse the word, by issuing a governor's warrant. And since 1976, not a single governor has upset a death sentence in the state of Florida.
I want to come back to the part about the judge. If the jury were to recommend death, the judge does not have latitude to then turn around and say life, or vice versa. So clarify for us people what a verdict from that jury means. Is the judge bound by that, whichever way they go?
The judge is not necessarily bound by that as far as having to give the death. The judge is bound by having to give life.
Many months of testimony to come from both sides in this case. We know that we've only begun to look at the legal issues. We'll be calling on the three of you, I am sure, many times in the coming months. We do appreciate you with your legal expertise, Lourdes Casanova, Mark Aggravators, and Doug Rudman, for taking time to be with our audience at this, the outset of the sentencing phase of this case. Some 4.5 years ago, it all began on that day, February 14th, 2018, with the death of 17 people at Marjorie Stoneman Douglas Senior High School in Parkland. And now we and a national audience, by evidence of all the assembled media here today for many months to come, will look to see this court process play out. We'll have coverage throughout, both online and on air. For now, and again, please join us beginning at 4 for our on-air coverage. For now, I'm Michael Williams with Doug Rudman, Ms. Casanova, Mr. Aggravators. Again, thank you for your time. Thank you at home, and we will see you soon on WPTV News Channel 5 at 4 o'clock.